Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, and my name is Jim Santelle. I am your host for this hour and also next hour here on the broadcast stations of Civic Media. Delighted to have you with me for this, our weekly weekend review, our analysis, our deliberation, our consideration of major stories in the areas of law and government and the aspiration for justice in America and beyond. As always, we are taking your phone calls and your inquiries, your questions here at the Civic Media stations. That telephone number is 855-752-4842. And Max, my wonderful producer, also tells me that you can be in communication with us as well by dropping a question and inquiry into the Civic Media line, letting us know what you're thinking about, asking questions about our always ambitious but achievable agenda. And yes, we've got just that going on this weekend as well. Let's talk first about what is on that syllabus for this weekend show. We're going to begin exactly where we ended off in our last broadcast of last weekend. And that is once again talking about guns in America, the problems that we are facing, not only in the nation generally, but certainly right here in Wisconsin as well, as we were reminded graphically and horrifically on Monday of this past week. We're going to talk a little bit about what happened on Monday at the Abundant Life Christian School, the latest mass shooting here in the state of Wisconsin. We'll give you some statistics on the nature of the problem, which visits us here in Wisconsin and throughout the nation. We're going to talk beyond that about the problems we are confronting routinely in America, have continued to confront guns in America. Not only a law enforcement issue, which is the reason why we bring it up here on Amicus, a law review, but also a healthcare issue. It is a healthcare crisis in America when these kinds of things continue to happen. Guns in America, once again, visiting not only our agenda, but visiting our lives and our livelihoods in our nation and our state. Reminded as well where we stopped off last broadcast talking about the Glock. Probably the 3D printed Glock that was used by Luigi Mangione to kill Brian Thompson, who of course is the CEO of United Healthcare, on December 4th of this month. We're going to chat generally about guns in America as a part of our initial discussion and review of challenges facing us here in our nation. Also going to talk about the mechanisms by which Luigi Mangione has been and is going to be prosecuted by both state and federal prosecutors. We'll tell you something about the nature of those parallel charges going on with respect to Mangione and that investigation, the prosecution in both state and federal venues there in New York. Then necessarily staying somewhat in New York, we're going to talk about two major developments having to do with those continuing criminal cases against our president-elect, who takes office in a short 30 days from now. We will spend some time chatting about a major thing that Juan Merchan, the New York justice, the judge presiding over that hush money false statements case, what he did just this past week that signals that at least there is some continued life in that prosecution, if not in the long-term future. We'll tell you about what he did in connection with the United States Supreme Court's decision of just under 6 months or so ago, finding that, in fact, presidents have immunity for crimes committed in office. We'll tell you how it is, according to Juan Merchan, that particular decision does not prevent him from going ahead with the further administration of that case and the prosecution of it by District Attorney Alvin Bragg in that venue. Much related to it, but in a variety of different areas. In Georgia, in particular, Fani Willis, the subject of a major appeals court decision of just this past week as well, finding that indeed she does have to be removed from the case, as does her office. A decision, a major surprising decision from the appeals court there in Georgia, overturning the decision of Scott McAfee, Scott McAfee, the trial judge who found previously that her relationship with a coworker on the prosecution team, not a conflict of interest, but nonetheless an appearance of impropriety, sufficient to compel that coworker be removed from the case. We'll talk about what the appeals court did, what happens next in both that case in Georgia and also the state of New York, that state case pending in front of Juan Merchan. What's next? What's coming up next in both of those cases? Next on our agenda, again, our ambitious but achievable agenda this weekend, we're going to talk about the merits and, yes, the demerits, the considerable demerits of that lawsuit a civil lawsuit brought by our president-elect against a number of people, including the Des Moines Register, an attempt to thwart, if you will, the First Amendment rights and prerogatives of the media in our nation to print legitimate news, including here the results of a poll that turned out to be wrong, but nonetheless a poll that existed at the time. We'll talk about the merits and demerits of that particular prosecution and the real reason why it has been brought, again, to limit and to try to scare off the legitimate work of media in our nation. And then we're going to go overseas and do the third installment of something we've talked about at great length on past broadcasts, and that is the remarkable, stunning, shocking prosecution of Dominique Pellico and 49, almost 50 other men for the vicious and horrific sexual assault upon Giselle Pellico and arguably other people over a period of a decade. That case, after months of prosecution, it was basically their O.J. Simpson case there in France, riveting attention by virtually every member of the French population. That case now being brought to conclusion with the findings of guilty and the imposition of sentences on all of them. We'll tell you exactly what the court panel did in France. And finally, coming back to the United States, another high court review, and that is what our Supreme Court has done just this past week. Last broadcast, we talked about the decisions that the Supreme Court has made in not granting writs of certiorari to various cases pending out there. We're going to chat this week about 3 cases that it's decided to review, to analyze, to hear oral argument on, and ultimately to decide, presumably sometime in 2025, probably later into the spring and summer. One case involving TikTok and the legislation that was signed by the president, passed by the Congress with respect to its future here in America. A second major abortion case having to do with Planned Parenthood, that now on the docket of the United States Supreme Court. And finally, some issues related to religion. Once again, a First Amendment issue. This one not about media, but about religion in America. And the question about whether or not charities have to pay unemployment taxes, the connection between government and charities, never before addressed by the Supreme Court, although lots of precedent plainly in the other area of the intersection of government and private entities, public entities as well. We'll chat about those new cases now on the docket of the United States Supreme Court as of just this past week. All of that, again, on Amicus, a law review in this hour and also next hour. Once again, inviting you to be a part of our conversation. That number, once again, is 855-752-4842, 855-752-4842. Always interested, always soliciting your questions and your inquiries about things that are on our agenda. We are sobered and we are always thoughtful about guns in America, especially when those sobering events bring us again to confront the decisions being made today by our legislatures, many of them, including right here in the state of Wisconsin, not to act, to do those things that we know they can do, that we can do, that will not completely eliminate, but will reduce the incidence of gun violence in America. We know a lot. We know a lot about gun violence in America. We know that in 2024, this calendar year alone, we've got 10 days left. There are more than 488 mass shootings in this year alone. We've got 10 days left. Probably going to reach another, not landmark, but significant numeric event here. Probably more mass shootings in the last days of this year. Again, going to populate the terrible news in our nation about mass shootings. Mass shootings generally defined as shootings involving 4 or more people. Some of them may be killed. Some of them may be injured. 4 or more individuals shot in the course of one particular event. In each of the last 4 years in America, there have been more than 600 mass shootings. That's almost 2 a day in our nation. About 50 people are killed every day, not just from mass shootings, but in other areas and other ways, are killed every day from firearms in America. In 2021 alone, according to the Centers for Disease Control and Prevention, almost 49,000 people lost their lives. They died as a result of gun-related injuries in America. More than half of those suicide-related. We know as well, based upon an awful lot of calculations out there, that the numbers of guns exceeds the population of the United States of America. Almost 400 million guns in circulation right now. Of course, that's not to say that every American has a gun, but just that we've got lots of guns out there. Lots of guns out there to cause the kinds of tragedies, the human tragedies that we have seen again in recent weeks, months, years, and again, just this past week. And that includes, of course, here in Wisconsin, in Madison. Medical examiner this past week finally naming the 2 victims who died in the shooting of this past Monday at the Abundant Life Christian School, attracting, of course, appropriately, the national attention, the world attention. Once again, another mass shooting in America. The identified victims are Ruby Vergara, who's 14. She's a student. She was a resident of Madison. And Erin West, she was 42 years old. She lived in nearby DeForest, Wisconsin, listed in his staff directory as a substitute coordinator at the Abundant Life Christian School. We know from all of the reporting that a second-grade teacher called 911 at about 10:57 a.m. on Monday to report a shooting inside the school. That reported now accurately by Chief Sean Barnes of the Madison Police Department. Chief Barnes, again, providing some information about what happened that day, including the injuries suffered by others who were taken to the hospital. The names that identification of those not yet publicly identified, at least two in critical condition as a result of this mass shooting at the Abundant Life Christian School here in the state of Wisconsin, just in our area, just outside of the downtown Madison area there. The shooting took place again in the midst of our greater concerns about guns in America. We'll chat more about that as Amicus, a law review, continues here on the broadcast stations of Civic Media. This is Amicus, a law review. My name's Jim Santelle. I'm your host this hour and next hour as well for our discussion of all things related to government, law, and the aspiration for justice. Beginning our broadcast again this weekend, as we ended our broadcast last weekend talking about guns in America. We know what can solve, if not completely, but go a far way in solving the problem of guns in America, the continued onslaught, not only of mass shootings, but these horrific numbers of deaths as a result of gun-related injuries. We know what can solve those kinds of things because we've had history in some of this. We had a 10-year moratorium on assault weapons in America back in the 1990s. And we know that as a result of that, the number of these kinds of mass shootings declined, especially those, of course, using assault weapons of the kind that were prohibited. That law, that federal legislation sunsetted, has never been put back in place. And so the numbers of assault weapons there has continued to grow, as have the number of injuries caused by them in America. We know that simple things, appropriate things, like universal background checks, closing the so-called gun show loophole here in Wisconsin and other places, would have a dramatic impact upon access to guns by people who are by their very nature violent, who should not have weapons. That is a way of solving this problem. Talked before about the fact that many of these cases, more than half of them, involve suicides. We know that in those states that have imposed and established what are called emergency violent protective orders or emergency response protective orders, these are the processes by which individuals, family members, typically identify someone in their family, in their region of knowledge, who seems to be in a threatening position because of a psychological or mental issue, and yet has a gun. And under those circumstances, these laws permit those caring family members, those caring community members, to see a judge and say, "Judge, this particular person who I care for, who I love, I'm concerned about, has a gun and seems to be suffering in some way. Impose upon us all, direct the local law enforcement to go out and remove that gun temporarily, not permanently, temporarily from that person, to prevent a suicide, to prevent that person from engaging in any other violent conduct which would affect the life and the livelihood of someone else." Those are emergency response protective orders, sometimes also called red flag orders or legislation in the area. We know that those work. We know that those work because they happen routinely in America and can solve these problems as well. Inside homes, we know that legislation and laws that require safekeeping of weapons also keep weapons outside of the hands of young people and other people who might otherwise have access to them in ways that could compromise safety and security. There are a host of things that can be done legislatively, and can also be done by others in our community. And that includes not just in the wake of what happened in Madison, but in other situations, the American public standing up and saying no more. We know by virtue of the statistics on all of this and polls taken, the American public overwhelmingly supports these kinds of things that would prevent the kinds of gun violence that we saw again in Madison, other places around the nation. We know that the population of America supports them. And indeed, just this past week, in the wake of the horrific shooting there at the Abundant Life Christian School in Madison, more than 100 people, led by teens, protested the failure of our state legislature to act in some of these ways, invoking the horror of what happened at the Abundant Life Christian School. More than 100 people, mostly led by teenagers, took to the state capitol, the building itself in Madison, to demand action from lawmakers. Just on Friday of this past week, a crowd walking through the halls, signs chanting "No more silence, end gun violence." It was a chant that was echoed by Representative Francesca Hong. She's from Madison. She said she was thanking the Madison High School students who braved the cold to come protest gun violence at the Capitol. She said, "We as policymakers need to do better for you. On behalf of you, the Abundant Life Christian School community is equally in our hearts and our minds today." And she also, as do all of us who care about these things, recognize that hearts and minds and caring thoughts important, but they do not get the job done. And so we need to call upon legislators once again, not just in memory of the two victims, the others who were injured just this past week in Madison, but the many, many other people, the 49,000 people who have died of gun-related injuries every year in America, the 600 or so mass shootings in the last 4 years. We're on track now, approaching 500 mass shootings in 2024 alone as we begin to close out this calendar year. On behalf of all of those people, for the safety and security of all of Americans, we need to do better. We need to invoke those things that we do know work and make them happen. Meanwhile, of course, law enforcement, including law enforcement right there in Madison, continues to focus upon the gun, the 9mm weapon That's a part of the investigation, of course, that comes in the wake of that shooting at Abundant Life. Plainly, lots of questions about where the young shooter who took her life, one of the three victims there at that time, where did she get that gun? And certainly that is the focus of a lot of law enforcement activity right now. We don't know. We don't know about this. We don't know exactly where it came from, how she got access to it. But we do know that there is some precedent out there for holding adults responsible for failing to do the things that they need to do. And not just turning a blind eye, but affirmatively not doing those preventive things that must and should be done to keep young people from going into schools and other places of common assembly and using weapons to catastrophic result. We know about Jennifer and James Crumbly, given at least 10 years in prison coming out of that Pontiac, Michigan, Oxford High School shooting in late November of 2021. Just 3 years ago, 4 students horrifically killed, another mass shooting in that state. Parents convicted of involuntary manslaughter and sentenced again to at least 10 years in prison, beginning to hold parents responsible when they fail to do, in that case, the most clear and obvious things to prevent those kinds of mass shootings from happening. We don't know. We don't know yet what happened in Madison, how that young shooter got that 9mm weapon. But that's the subject of continuing investigation, continuing pursuit by law enforcement there in Madison, appropriate to do it even as we work with legislators to get the results we need to get in America. All of that, our continuing discussion coming out once again of our own state here in Wisconsin. We are also mindful, of course, of the Brian Thompson assassination on December 4th in the streets of Manhattan. That, of course, perpetrated by Luigi Mangione, who just this past week was brought from Pennsylvania, where he was apprehended. He was moved now to New York, and he is facing, interestingly, both federal and state charges. We're going to get to that in just a moment or so. Plainly, he is in custody for the shooting. Not a mass shooting there, but using a gun once again. And interestingly, more and more indication that the gun that he used, as we began to talk in our broadcast last weekend, was a 3D printed gun using a popular design that's found online. At first glance, that gun, if you see in some of the police photographs, the one that the authorities believe that he used to kill the United Healthcare CEO, Brian Thompson, appears to be a Glock, Glock 19, a 9mm semi-automatic pistol used by military forces and police officers, civilians and criminals, frankly, around the world, including here in the United States. But in closer inspection, actually appears to be partially at least produced by a 3D printer. We're going to talk about the access of guns and the possibility of using guns violently, putting them together from 3D printing, apparently, according to what appears to be the investigative results coming out of that New York issue, as we continue here on Amicus, a law review. name is Jim Santelle. This is Amicus, a law review. This is our weekly weekend review of things related to justice in America and beyond, necessarily talking as we have in the past about guns in America, including not only that horrific shooting in Madison of just this past week, but earlier this month, December 4th, the shooting of the CEO, Executive Brian Thompson, on the streets of Manhattan, talking about the gun that was almost certainly used to perpetrate that horrific crime. Initially appears to be a Glock 19, a 9mm semi-automatic pistol, but in fact, probably at least partially produced from, yes, that's right, a 3D printer. The giveaways, according to early indications, are subtle but clear. The Glock logo is absent from the pistol's grip. This is the weapon that is appearing again in photographs provided by law enforcement. The angle of the grip is somewhat peculiar. The indentations on the grip, known as stippling, pattern in such a way the gun's fingerprint can be directly linked to a unique free-to-download 3D printed design known as the FMDA 19.2 Chairman One Remix. That's the name of the 3D gun, the 3D items that are assembled to produce this particular gun in all likelihood. Now, homemade firearms, as we know from past reporting, and indeed from discussions before the United States Supreme Court, they've existed actually for centuries, fully 3D printed firearms around here in the United States and around the world since about 2013, as the Supreme Court engaged most recently in its discussion of ghost guns. Talked a lot about hobbyists and the fact that hobbyists are ones who often produce these homemade 3D printed firearms. The rules and regulations vary by state. More than 25,000 privately made firearms were recovered in domestic seizures in 2022 alone, according to the United States Department of Justice. In some countries, not ours, with some more strict gun laws, these 3D printed weapons, which can be difficult to detect and trace by their very nature, are being used increasingly in crimes, leaving law enforcement agencies struggling to stop their proliferation and indeed causing problems for us here in America as well. We know that the pistol recovered from Mangione was not made up entirely of 3D printed parts. It had some metal components in it as well. Those apparently include the slide, that's the top portion of the gun, and also the barrel, which appeared, according to photographs, to be threaded, which allows a suppressor or a silencer to be attached. The pistol's magazine, according to viewing of it, which can often carry more than 10 cartridges and retails for around $25, appeared to have been store-bought. So it was a combination, kind of a hybrid of a 3D and other items not made in 3D processing. The issue of guns, once again, looming large in America. And we know as well as I've indicated this weekend, but also in previous discussions, that guns continue to be the subject of a lot of focus by the United States Supreme Court. Most recently, in October, as we have reported and discussed right here on this broadcast, the Supreme Court taking up this case called Vanderstock, Garland versus Vanderstock, a challenge to the ATF rule that attempts to keep us a little bit safer, a little bit more secure if, in fact, guns are involved in violent activities. The rule established under the Biden administration by the present ATF requires that for ghost guns, that is these kits that you can order online, your component parts, that they have serial numbers on the component pieces. Why is that? So that when you put them together and you create a firearm that in fact can work according to the way a firearm is defined in federal law, when you assemble that, if that gun is used in a crime of any kind, it can be traced. Therefore, we can find out where it came from, easier to trace it as a part of the all-important law enforcement work going on certainly right now in Madison, going on in New York, and in other places around our nation where guns are involved in crimes. The United States Supreme Court taking up this case called Vanderstock in October, as we have discussed at length, and for the most part, seeming to indicate that they probably would support the decision by the ATF, by this administration, to impose this, what's frankly a very modest regulation. We're not talking about shutting down ghost guns entirely, although it could have that that affect long-term economically, but requiring manufacturers to place serial numbers and other identifying information on those component pieces, again, for purposes of law enforcement tracing. Not a huge imposition, but nonetheless, Vanderstock and others challenging that as a violation of Second Amendment rights under those cases called Heller and Bruin. We've talked a lot about those as well. The United States Supreme Court appeared not to buy into the notion that somehow those Supreme Court prior cases require that the ATF stand down and rescind or be pushed back on the enforcement of that rule. And that's the way things stood in October of this year. And then something significant happened in November. And that is that we elected a president who almost certainly is going to change that ATF rule that keeps us somewhat more safe and more secure by imposing this regulation upon ghost guns in America, indicating likely that he would, in a Trump administration, rescind that rule. And what would the effect of that be? Well, again, enabling the use of these guns in crimes and in other settings that prohibit the capacity of law enforcement to trace them accurately and promptly. Of course, before the Supreme Court, what that would mean is that the case almost certainly would be withdrawn. And the likelihood that we would get in May or June of this coming year a definitive decision by the Supreme Court that indeed federal agencies can do things, can rule in ways that keep us safer and secure. A larger theme that we talk a lot about here on our weekend broadcast, the capacity of agencies to engage in the work that they should be doing to keep us safe and secure, probably not going to be decided by the Supreme Court because of the likely withdrawal of this rule. Therefore, the mooting, M-O-O-T, becoming moot, that case before the Supreme Court, and therefore probably by the next Solicitor General under the Trump administration, probably removing that case from the Supreme Court docket because there's no more challenge to a rule that would no longer exist. And that is not a good thing, but it also underscores the significance, of course, of changes in the presidency. The significance of your vote for the presidency of the United States of America has an impact upon violence in America, gun-related violence, and the ways in which we can do things to keep us all more safe and secure, not just in New York, not just in Wisconsin, not just in Madison and Milwaukee, and in La Crosse and Green Bay and Stevens Point and Eau Claire and all places around our state, but in every community in our nation. Guns continue to be a very significant issue for us all to discuss and to be a part of the advocacy to address the issue legislatively, but also in our public domains. Delighted to have joining me for some of our discussion this morning, a good friend, colleague here on Civic Media, an icon in Milwaukee, throughout the state of Wisconsin and beyond, who is an articulate voice for all of this, and he's Earl Ingram. Earl, glad to have you with me this weekend. How delighted it is to be a part of conversation with you today and always.
It's an honor and a privilege, my friend. I would just say that all those accolades that you talked about before my name, I don't know who that is. Earl Ingram. I know
who it is.
Quickly, I live in a city that is in urban centers across this nation where blood runs in the streets.
Yes.
Daily. Children, 5, 6, 8 years old, killed with regularity by guns. 12, 13-year-old children who have accessibility to guns that have been turned into automatic weapons because somehow they can purchase things that are created for God. God only knows why somebody creates something that can turn a handgun into an automatic weapon. But as bad as that is, it's easy for these young people to get their hands on it. For God's sake, we live in a nation where less than 40%. I mean, 40% or more of the American people own guns. 60% of us don't. Mm-hmm. Why are we held hostage, Jim, by 40% of the people who own guns? The majority of us don't want that.
Right.
So we just saw this horrific event in Madison. There'll be others. It'll continue. Americans make up 4 of the global population, yet most of the killings, we kill more people by guns than almost the rest of the world combined. So we know this. We know this makes no sense, but yet the people can't control it. They have the lobbyists have control over our elected officials. Many of the American people don't even understand the process. And so here's where we are. We'll continue to be in this condition. Jim, it's heartbreaking that the American people don't understand this. The majority of us apparently don't understand it, and yet we're held hostage. It's a great topic. It's hard for me to believe that we're still here.
We are still talking about it, right? Right. And this earlier.
Yes, sir.
Absolutely right. And again, a couple of thoughtful follow-ups on your terrific commentary, which is we've got a Supreme Court that, again, last term said, you know what, the ATF cannot regulate exactly what you were just talking about, these bump stocks that can turn semi-automatic weapons, pistols into machine guns, basically, weapons of war. Supreme Court said, no, you can't regulate those. There's a problem there as well. People, as you just said, Earl, we need to be demanding better of our appointed representatives, in that case on the Supreme Court. Our elected representatives can pass legislation to address those kinds of things. And then, as you've been advocating throughout your career, and again, I look to these 100 mostly teenagers who took to the Capitol just on Friday of this past week and said no more. The next generations, we are passing along this legacy of a nation run rampant when it comes to guns. We know what can solve this problem. Repeating your rhetorical question, why aren't we doing it? Why are we not doing it? We need to do better. We need to do better in 2025. Maybe that's one of our resolutions to go forward, my friend, and work more on addressing this issue, getting it done, because it hasn't been done up to now. Earl, I thank you so much for your calling in, your commentary. As always, good to be with you. We will chat more about that with you and with your listeners as well on Civic Media about all of this as the issue continues to plaguing our nation on a weekly basis, a daily basis, and with clear signs about what we can do to remedy the problem, and yet do not have the political will, apparently, to do just that. Coming out of that Luigi Mangione horrific assassination in New York, also some interesting legal issues having to do with the way in which he has been charged. As I indicated further, Mangione now back in New York, facing both federal and state charges. Federal and state prosecutors charging him just this past week with the killing, again, of that chief executive in Manhattan. It's sort of a two-pronged legal offensive that's going to maybe not complicate, but sort of add two dimensions to this. The Manhattan DA's office charging Mangione with one count of first-degree murder. That's a terrorism-related offense. Also charging with 2 second-degree counts and a weapons crime as well. Interesting, while those state charges are brought against Mangione, the U.S. Attorney's Office, this is the U.S. Department of Justice, these are the federal authorities, Southern District of New York, charging with 1 count of murder, 2 counts of stalking, and a firearms offense. Again, to some extent, both of those kinds of charges addressing what Earl and I and all of you have just been talking about. The maximum punishment for state charges is life without parole. If convicted on the federal charges, Mangione could face the death penalty, which is significant, of course. The state case almost certainly go to trial before the federal one. State prosecutors said they would coordinate, as they always do with federal agencies. What do we know about the prosecutions, these parallel prosecutions? Well, there's precedent for this, plainly, federal and state prosecutions going ahead. We have seen this before in the parallel prosecutions of the Minneapolis police officers who killed George Floyd. Remember that? Of course, you do very well. Among the cases that followed a similar path. Another case in that category, the 3 men who killed Ahmaud Arbery in Georgia. All of those federal and state cases as well. Talking more about the implications of parallel proceedings here as Amicus, a law review, continues. Jim Santelle. We're spending our entire first hour talking once again about firearms and these events in New York, in Madison of just this past week, just this past month, involving, again, violations of our basic norms, our right to be safe and secure in our public schools, our private schools, our places of community. Noting that in response to the horrific shooting in Manhattan in early December, just recently, both federal and state authorities have prosecuted or brought charges against Luigi Mangione for his violent behavior there. These charges, not unprecedented just before the break, indicating that we've seen this in the George Floyd prosecution. Those officers in Minneapolis charged and ultimately convicted of both federal and state offenses. Why? Why? Because they vindicate, they resolve, and they address different kinds of issues. You can violate federal law while you're also violating state law. We also note that we saw this in the three people, the private citizens who killed Ahmaud Arbery in Georgia, that horrific event. Also prosecuted in a civil rights case, as a murder case, federal and state authorities. The cases against Mangione differ, yes, undeniably. State prosecutors are arguing, of course, that Mangione committed an act of terrorism, as we've seen the DA there. Their federal counterparts, again, the U.S. Attorney's Office down the street, U.S. Attorney's Office there, said that he stalked Brian Thompson, who's the United Healthcare executive, before killing him. Now, there is some tension, if you will, between those two cases, because stalking, of course, is usually directed at a specific person. New York defines terrorism as the intimidation or coercion of a civilian population or government. And so it seems to be, on the surface anyway, that those two theories of prosecution might run up against each other, but in fact, they're not irreconcilable. You can stalk an individual with the intent to intimidate or coerce a government or a population, if, for example, if you were stalking a public or political figure. Now, all of this, of course, also raises an issue that many people ask. What about double jeopardy? If you're charging someone with basically the same offense conduct, the underlying facts are the same, but you've got different kinds of charges in different courts in different jurisdictions. What about the double jeopardy clause that prohibits you from being prosecuted twice for the same offense? And the answer is that the federal government, the state government prosecutions do not run afoul of double jeopardy, because they're separate sovereigns. The federal government, state government, different sovereigns in our legal terms. They run around, if you will. They don't really violate in any way double jeopardy. They basically are rules that have been established over many years, including by the Supreme Courts of many states, and certainly the United States Supreme Court, that say that double jeopardy not violated when different sovereigns bring different charges for the same conduct. There's a reason for the federal government prosecution. There's a reason for the state prosecution. And as I said before, they vindicate, they approach, they address different kinds of issues. And so the significance of these cannot be overstated. Very likely, the state case, as is often the situation where you've got parallel proceedings, the state case almost certainly to go ahead first. We'll get a trial, if anything. Maybe there'll be a plea ultimately, but perhaps a trial. That will go ahead in New York. And then, depending upon the results of that case, a federal trial could proceed as well. In the meantime, both of them can go forward in their particular courts in parallel proceedings. Often the federal court sort of stays back and lets the state court proceeding go ahead to some resolution. Interestingly, again, depending upon what the Department of Justice, the incoming Department of Justice, does, it is entirely possible that the Justice Department under President-elect Donald Trump might want a trial to win a death penalty with respect to Mangione. That is plainly accessible under a federal charge, which you now have present. Present Attorney General Merrick Garland, present president, has moved back from the imposition of the death penalty. A new president coming in with these charges, almost certainly continuing from the past, the present federal administration into the future, almost certainly will continue, could well seek the death penalty under federal law as those cases move ahead. Now, Mangione's lawyer, who is well known in New York circles and beyond, her name is Karen Agnifilo, said that this is a highly unusual situation. She said that there was absolutely no mention of a federal case when she appeared with her client in a state court. She said, I don't think they even knew that this was going to happen, speaking about the state authorities and the federal authorities. She said, "I've never seen anything like what is happening here." So plainly already defending her client, as she should do. Mr. Mangione is, as always, presumed innocent, is entitled to a defense in our system. A system cannot work without accurate and aggressive and informed and experienced law enforcement, and also equally aggressive and experienced and focused defense counsel in all these cases. She certainly has the right to say those kinds of things, but the reality is that there is precedent for this. And while she may not have seen anything according to what is happening here, as she just said, the reality is there's nothing wrong, there's nothing illegal, there's nothing unconstitutional with having two different sets of charges pending against her client. She plainly would be spending most of her time in the weeks, months, maybe even years ahead, principally in the state court, where once again the DA has charged Mangione with first-degree murder, which again is a terrorism-related offense, to second-degree murder counts and weapons crimes as well. All of that coming out of the horrific violence in Manhattan in early December, visited upon not just the CEO, but I would offer all of us, the victims ultimately of gun violence. As the police chief in Madison said so eloquently just this past week, there's not a single person in the broader community not affected by what happened in the horrific death of those two in Madison, the young student and the teacher as well. The others who are injured, all the members of the community affected dramatically whenever these kinds of things happen, because we're compromised in our safety and our security generally. We will continue to not only report on gun-related events and activities in our localities, in our communities, our states, and our nation, because these are important issues. And to the extent that we begin to think about 2025 and following up on the comments and the suggestions made by my good friend and our community advocate, Earl Ingram, let's make 2025 the year where in Wisconsin we can get some legislative movements on these kinds of things to keep us all more safe and more secure. As we finish up our first hour, just a program note as well. This coming Monday, I'm going to be sitting in for Maggie Dawn on Monday, December 23rd, and again on New Year's Day. On New Year's Day, sitting in for Maggie Dawn and her show, 2 to 4, the Maggie Dawn Show here on Civic Media. Also, of course, appearing next weekend and the following weekend as Amicus, a law review, continues on those settings and continues in the next hour here in our weekend program about law and government and the administration of justice in our nation and across the planet. Stay with us.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is the second hour of our weekly weekend broadcast, talking about all things government, all things law-related, all things justice-related. My name is Jim Santelle, your host for this, the second hour of our broadcast here on the stations of Civic Media. Delighted to have you joining me and my producer, Max, for our discussion about many things. The agenda, which is ambitious, continues in this hour as we move now into some updates and some commentary on significant things of just this past week in connection with those remaining cases against our president-elect. He takes office in a short 30 days from now, 30 days from now, after months and years of prosecution in 4 different cases. We know that those 2 federal cases, that is the federal insurrection case, the election interference case, and the Mar-a-Lago documents case, both of those now gone. Both of those now gone on the motions of this administration, of this present Department of Justice, to dismiss those cases, anticipating Donald Trump's taking the oath of office on January 30th. There are still 2 other cases that are pending out there, and interestingly, they're both the state cases. They're both the state cases, criminal cases brought against our incoming president. Let's talk about those because both of them have been in the news of just recent days. First of all, finally, Juan Merchan, the judge who presided over that weeks-long trial back in the springtime of this year, ultimately resulting in the jury verdict, a unanimous, beyond a reasonable doubt jury verdict, finding Donald Trump, our incoming president, committed violations of New York state law when it comes to false statements, false records in paying off Stormy Daniels for keeping quiet in connection with the 2016 election about a previous affair that Donald Trump had with her. We know all about that case. We also know about its sordid history since the time of that conviction, the return of the jury verdict by the jury in Manhattan. This, again, the state case being presided over by Juan Merchan. Almost immediately after that case, the case was suspended for months, the 6 months that have passed since that time, principally once again because of this horrific, unbelievable decision by the Supreme Court on July 1, telling us that presidents can commit crimes while they're in office. And the question then raised appropriately by aggressive and effective defense counsel, whether or not that particular decision of the Supreme Court applying to sitting presidents for actions in their official conduct, whether that should prevent the further prosecution, even post-verdict, post-judgment by the jury, should prevent Judge Merchan from going ahead with sentencing in that case. And he appropriately initially said, well, I'm going to take this under advisement. I want to hear from the parties about what they think, and both of the sides, but the defense, prosecution, both of them submitted their arguments to him. Ultimately rescheduled an initial sentencing scheduled for July 11th, right before the RNC was here in the state of Wisconsin, the city of Milwaukee. Postponed that then until September, also promising both a decision on the applicability of that Supreme Court case to the judgment of the verdict of the jury and the verdict there of guilt against Donald Trump. Then in September, postponed that again until November, right after Thanksgiving, right before Thanksgiving, right after the election, on the basis that, well, we're right in the middle of the campaign now, would be inappropriate for me to do something that might skew that result. But all along promised to do 2 things. One is to decide this case having to do with whether or not the Supreme Court's federal case on immunities by a sitting president applies to conduct by Donald Trump prior to his being a president, and things done in his official or more likely unofficial capacity, argued vociferously by both sides. And yes, indeed, finally, just this past week, Juan Merchan issues a ruling rejecting Donald Trump's argument that that Supreme Court case nullifies or removes that criminal case in New York. So basically upholding the former and the future president's felony conviction for falsifying those records. That is no small thing. That is no small thing. And Donald Trump to this day remains a convicted felon in the state of New York for having violated the rules, the laws of the state of New York. The decision by the judge there, of course, long awaited in the wake of not only the Supreme Court decision, but also the jury verdict, long awaited. But now ponies up. It now provides a basis for the judge to do the other thing. You've heard me talk about this before, which is to do the other thing that we do with respect to the administration of justice in America, state systems, federal systems, even local systems. After a defendant is convicted, after post-trial motions have been resolved, and yes, indeed, there's still a small additional post-trial motion that's related to the issue of whether or not the mere presence of the defendant in court, that is a defendant who's soon going to be the president of the United States of America, that anticipated role of the presidency, does that in and of itself prevent a sentence being imposed right now? That motion's still pending. You'd like to think that Judge Merchan can resolve that fairly expeditiously based upon his recent decision, but he's still got that pending. But let's assume that he's going to resolve that one as well and equally deny that and say that the defendant, Donald Trump, has no merit to that particular argument. Then he should do, that is, Juan Merchan should do what every other judge does in bringing a case to resolution. That is, should sentence the defendant 30 days out from today. 30 days, a month before Donald Trump takes the oath of office. And yes, that is something of a watershed date, not only in the history of America, that's a huge date, but also a watershed date in the prosecution itself, because at that time, you will have a defendant in a state court proceeding who is also the chief executive of the federal government. No small thing. And that is the reason why I've been so very clear about advocacy for, as have others, admittedly with a prosecution bias, a prosecution perspective, but also a perspective that comes from law enforcement generally bringing a case to resolution. Juan Merchan should now do what he has promised since the return of the jury verdict way back in May, as he promised in July, as he promised in September, as he promised in November, to do this other thing, which is to sentence the defendant. And yes, indeed, that sentencing proceeding happens in New York, is not a weeks-long matter. It can be taken care of over the course of probably hours. You give it the opportunity to the defendant to say what he wants to say. That's the right of allocution. Give his attorneys the opportunity to recommend to the judge what they think should happen here. You give the prosecution the opportunity likewise to recommend a proposed sentence, and you resolve the case, bringing it to conclusion. Couple of important things, as we've talked before. Even if the judge decides to impose a prison term, any term could be stayed, could be suspended pending appeal. The judge would almost certainly do that, not requiring that this defendant go to prison, be incarcerated for any period of time in the immediate future, including the time as he takes the White House and resumes the presidency. And during that period of time, you can also pursue the appeals, which will necessarily come not only with respect to the jury verdict and jury instructions and evidentiary things returned by the judge during the course of the trial, decisions about trial testimony and documents, certainly things related to this post-verdict period, including this decision of just this past week saying that the Supreme Court case does not prevent the future prosecution. All of that wrapped up in appeal. Donald Trump can appeal any and all of those issues to the next level, which is the appeals court in New York, and ultimately to the Supreme Court in the state of New York, and maybe ultimately to the United States Supreme Court, which does in fact have jurisdiction over decisions of state courts of the highest level. All that can continue to happen without doing an injustice to the basic proceedings of criminal procedure in America. So the question is now, in the wake of the judge finding that the decision by the Supreme Court does not apply, will he move now? Will he now sentence the defendant at some point, not obstructing in any way Donald Trump's capacity to take the oath of office in 30 days or whatever the period of time may be between sentencing and the oath of office on January 20th, but permitting this case to go ahead, not only for the resolution of it, to perfect the appeal, to ensure that that can proceed apace, but also in the broader interest of justice, sending the message to all of us, including the many other defendants who are out there in the federal system, the state system, that yes, indeed, due process applies to everyone and that no one is above the law. The judge just this past week has said definitively in his decision that the Supreme Court case does not prevent that from happening, specifically focusing upon this notion that the introduction of evidence during the course of the trial of official acts might have had an implication for private misconduct. That was one of the curious things, you may recall, that the Supreme Court said in a portion of its opinion in that Trump versus United States case, something that Amy Coney Barrett was also scratching her head about, but nonetheless invoked by the defense appropriately in their defense of this defendant. The judge in his decision just this past week saying the people's use, meaning New York, the prosecutor, the DA, the use of these acts as evidence of the decidedly personal acts of falsifying business records poses no danger of intrusion on the authority and function of the executive branch. 41-page opinion saying that, basically saying that what the Supreme Court was concerned about is somehow affecting the capacity of a president to act accurately and with clarity and with due deliberate speed. Nothing about that. The personal acts pose a danger of intrusion upon the authority of a president to act. And so no effect here whatsoever. He said, and even if the evidence was admitted in error somehow during the course of the trial, that error was harmless. That's the harmless error instruction. That's the harmless error concept that we've talked about a lot, which basically says that even if there was error made, the evidence overall so very overwhelming that it would not have resulted in a different verdict by the jury. He went on to say, the overwhelming evidence of guilt introduced at trial makes it clear that this particular judgment, the verdict by the jury, has to stand. Now, all of that, of course, means that the case can now be wrapped up with a sentencing. Not to say it will be. An awful lot of proposals here that the case either be dismissed entirely by, as the defense has advocated, by the judge, that somehow be put on hold perhaps for as many as 4 years. We take this up again in 2029. Talk about justice being delayed, also a peculiar result. This very peculiar result we talked about last time, proposed by the prosecution, by the DA, that somehow we consider Donald Trump to be in a death status, and therefore his conviction, his judgment will remain, but nothing will happen with it. Highly peculiar. The best one is the normal one, the natural one, which is sentencing. You can still do it. Get this resolved, get the appeal underway, and get this matter, the one of the four that probably will result in some resolution of clarity among the four before Donald Trump takes his presidency. And that leads us to the other case. That is the case in Georgia. Another major event happening just this past week in an appeals court, coming out of the state appeals court there in Georgia. As Amicus Law Review continues, we'll talk about what happened there and why that decision also sends a big message about what will happen in that prosecution as our broadcast continues. This is Amicus Law Review. My name is Jim Santelle, reviewing now these major events having to do with the criminal cases pending, yes, still pending, against our incoming president, Donald Trump, even as he looks forward to taking the oath of office on January 20th. Another major event coming out of Georgia. This is the case, the state prosecution, not a federal prosecution, state prosecution brought by grand juries, plural, in Fulton County, Georgia, alleging election interference by Donald Trump and about 18 other defendants in that case, all sorts of things Same as the federal case in many ways, because it alleges very generically the broad kinds of things that were set forth in that federal indictment against Donald Trump. But this one, many more defendants, and this one brought principally under RICO, the Racketeer Influenced and Corrupt Organizations Act in Georgia, alleging that they actually engaged in a criminal enterprise to undermine and steal the votes in Georgia of the people who voted in that state. Well, that case, again, going ahead on various pretrial matters, pending before Judge Scott McAfee. You may recall well his work in this case. He's already dismissed about 6 counts of the indictment in that case. That also going up on appeal. But along the way, you recall well this issue related to Fani Willis's having a romantic relationship with one of the other members of her prosecution team, drew a lot of attention, prompted defense counsel on behalf of many of the defendants, ultimately including Donald Trump as well, to challenge her capacity to serve as the prosecutor in that case because of this inside internal relationship, maintaining that somehow she has a conflict of interest in prosecuting that case. The theory, very, very skeletal, very, very razor thin, almost not existent, that somehow she gets some economic benefit from doing this by virtue of the relationship and her prosecution of this case. It was a stretch to begin with, and that's exactly what Scott McAfee determined in the end. He said, no conflict of interest of all under Georgia law, entered that decision. But he also said that because of this romantic relationship, it caused an appearance of impropriety, and that among the public that has a right to have a sense of integrity and solid in the belief that the prosecution is going ahead with that kind of integrity, said that causes an appearance of impropriety, does not require that the case be dismissed, but that the other person on the prosecution team with whom she is having this romantic relationship, that he would leave. And indeed, he did leave. He resigned within about an hour or two after the judge making that determination. In the wake of all of that history, which really is a sideshow to the ultimate prosecution of this case, the defendants took up that decision on appeal, as they can. And they appealed that then to the Georgia Appeals Court. And it's been pending since that time, basically stopping Scott McAfee from further presiding over in the pretrial matters, as Judge Juan Merchan did before the trial in New York. He hasn't yet tried this case, so we don't have any post-trial matters, but moving apace with various things. All of that suspended while this issue of whether or not Fani Willis should be taken off the case, including her office, or whether or not this appearance of impropriety was sufficiently satisfied by the removal, by the departure of this co-worker, this co-member of the prosecution team who leaves that team. Well, it turns out, much to the surprise of many people, that the Georgia Court of Appeals just this past Thursday disqualifying Fani Willis, the Fulton County prosecutor who brought this election interference case and prosecuting it vigorously against Donald Trump and his allies, surprising many people, and again, causing some additional disarray in this one of the 2 cases that still remains pending in the criminal arena. And 2-1 decision, a 3-judge panel there, reversing the decision of the trial court, Judge McAfee. Again, in March of this past year, he did permit the case to go ahead, requiring that this other individual leave the prosecution team. No reason to dismiss the case at all. The office, again, supervised by Fani Willis, swiftly, very quickly indicated they're going to appeal that decision to the Georgia Supreme Court. So we have not yet heard the last of this. She is not going away in the wake of this particular decision by the appeals court. She is going to take it up to the Georgia Supreme Court. And of course, if it stands at the Georgia Supreme Court, it causes great disarray. Doesn't mean necessarily the case will be dismissed. Indeed, the appeals court said that the dismissal sanction would be too extreme, but said that the sanction identified by the trial judge, Scott McAfee, was not sufficiently severe. That, in fact, to reestablish the sense of integrity among the public, what you need to do is you need to get Fani Willis off the case, take her office off the case entirely. And under Georgia law, there's a panel decision that will basically come about. The local district attorneys will meet. They will decide who it is that takes this case on in the wake of her dismissal, if it stands. And that's a decision that now will go to the Georgia Supreme Court for their decision, ultimately delaying this matter and certainly throwing it into dramatic disarray. Some dramatic disarray that was bemoaned in part by the one dissenting voice on the appeals court. His name is Benjamin Land. He said, you know what? We have no business overturning the decision of the lower court. We should have kept in place exactly what Judge McAfee had done. He said this. He said he was particularly troubled, that is Judge Land, by the fact that the majority, that is the two people who voted to throw Fani Willis off the case, the fact the majority has taken what has long been a discretionary decision, meaning there's judgment here. It's basically you've got the matter in front of you. You're looking at the witnesses. You're figuring out what their credibility is. A discretionary decision for the trial court to make. And we've converted it, he said, Judge Land said, to something else entirely. Went on to say this, criticizing, again, dissenting from this view that Fani Willis needs to be taken off the case. He said, if this court was the trier of fact and had the discretion to choose a remedy based on our own observations, our assessment of the credibility of the witnesses, and weighing all the evidence, then perhaps we would be justified in reaching the result declared by the majority. But he added, but we are not trial judges, and we lack that authority. Even so, Judge Land is not the presiding voice of the panel here. He does not win, and the two who decided that Fani Willis has to be off the case, they're the successful jurists, if you will, in this case. Theirs are the votes that stand. Significantly, Fani Willis recently won re-election, a landslide. The people apparently want her to keep in place, and that is the interest that the appeals court, at least two members of it, feel they need to vindicate by throwing her off this case. So we will see more about that down the road, but certainly in the wake of the dismissal of the federal cases, in the uncertainty right now of what's going to happen next in that New York State case, Juan Merchan has authority to go ahead and bring that to resolution. The Georgia case almost certainly now into some oblivion. Not clear on exactly what will happen next. Certainly nothing in the near future. If anything, further petitions, further arguments that while Donald Trump is president, that nothing should happen in that case as well. Whether or not the appeals court and the Supreme Court there in Georgia buys into that theory, whether all of that is suspended while Donald Trump is president, we do not know, but we'll continue to monitor all of this fascinating intellectual jurisprudence going on in America. And ultimately, as to all of these criminal cases, plainly no longer the significant prosecutions about which many of us spoke many months ago. When we continue, we're going to talk more about Donald Trump's involvement in litigation in America, including his attack through litigation on our media, as Amicus, a law review, continues. This is Amicus, a law review. My name is Jim Santelle. Turning now to the president-elect's litigation. His promise to, and apparently his working on meeting that promise to go after the media in America. Among the threats and among the actual lawsuits filed against media outlets without merit, their frivolous actions. Just this past week, Donald Trump suing the Des Moines Register. Latest legal action on Donald Trump's stated intention to and actual pursuit of the media. He has said, we have to straighten out the press. I have to do this, he is saying. Just this past week, this latest legal action on Monday, Donald Trump filing a lawsuit against a pollster named J. Ann Selzer, her polling firm. And here it is, the Des Moines Register and Gannett, which is the newspaper's parent company. They own a lot of other media outlets throughout the nation. The lawsuit, this is civil litigation. He has no right, of course, to bring any criminal litigation. The suit, which is civil, was filed in Polk County, Iowa. And according to all of the records on it, it is accusing Ms. Seltzer, again, who's the pollster here, of brazen election interference for a poll that published shortly before the election, showing that his opponent, Kamala Harris, the vice president, was leading in Iowa by 3 points. Now, we know in the end that Donald Trump won Iowa fairly handily, and as he has in the past. And again, on Monday of this past week at a news conference in Florida, he not only previewed this lawsuit, but explained once again the reason why he has to do this. His lawyers, interestingly, bringing this lawsuit not under any defamation theory, because he can't. We'll get to that in just a moment or so. But bringing this lawsuit under a particular variation of Iowa law. It's called the Iowa Consumer Fraud Act. The Iowa Consumer Fraud Act. That's the basis upon which he is bringing this meritless lawsuit. And that really is the point, that under this particular piece of legislation, the elements of the civil offense that he has got to establish there simply are not there. Here's what the complaint says that he brought. The complaint says that the releasing of the Iowa poll in the newspaper there constitutes a practice or act. The person here, in case of the defendants here, is how we'd understand the legislation. The person knows or reasonably should know is an unfair practice, deception, fraud, false pretense or false promise, or the misrepresentation, concealment, suppression, or omission of a material fact with the intent that others rely upon that kind of conduct. That's in violation, according to Donald Trump, and yes, his lawyers, who've got to know better, as set forth in his lawsuit brought in Polk County just this past week. The law specifically bans the deceptions or misrepresentations in connection with the advertisement, the sale, the lease of consumer merchandise, the solicitation of contributions for charitable purposes, all kinds of commercial things sort of related to material facts or things that can be seized upon with some clarity. And interestingly, it has been used in other areas that are instructive here. The Iowa Attorney General's office, for example, used it in a 2020 lawsuit against a stem cell therapy provider for allegedly unfounded claims about preventing agency. Again, kind of a commercial fraud notion. 2017, a court barred a provider of brain-boosting herbal pills from selling them in Iowa after another complaint from the Attorney General saying this is fraud. 2019, Attorney General served lawsuits and was successful against several nonprofit animal rescues that allegedly funneled dogs bred in puppy mills into communities that banned their sale. Again, fraudulent things perpetrated on the community. On the individual side, we've got cases alleging that a vaccine left a teenage boy bedridden. No support for that whatsoever. All kinds of cases out there in which the law is used for commercial purposes to stop commercial fraud. Not this case, not able to establish the elements of the offense. And so the question comes, what is Donald Trump and what is lawyers doing here? And the answer, of course, is what we know. This is not done to be successful. This case will be dismissed, but only after a long period of time. We'll get pretrial discovery likely. We'll engage in depositions, a financial imposition imposed upon not only the individual defendants, but also upon the register itself. which again is a legitimate journalism outlet. Plainly not perfect, but again, in this particular case, not doing anything in the nature of commercial fraud, simply publishing the results of a poll that turned out to be inaccurate. That in and of itself is not commercial fraud under Iowa law, and yet this proceeding will go forward with that discovery, with pretrial activities of all kinds, will not reach trial. The presiding judge will almost certainly dismiss it at some point, maybe in years ahead. We don't know. We don't know after motions are filed. But the point of this simply is to get the attention of America and to pursue this continuing allegation that somehow he has been victimized by media that's simply doing its job and threatening plainly to do more of this. We know that the Des Moines Register case is not the only one out there that he is pursuing and will pursue in the future. We know as well, as I indicated before, that this is not a defamation lawsuit. This is not the kind of thing where he can come in and say that the newspaper defamed him, because he knows, and his lawyers know at least this. The New York Times versus Sullivan, that's that 1964 landmark case that said that you can only sue media outlets if you show that you're able to prove the normal elements of defamation, that is the publication of something that's false and it's defamatory in a literal sense of the word, but also have to show that the statement was made with actual malice and the defendant either knew the statement was false or recklessly disregarded whether it might be false. Donald Trump now knows, maybe, but certainly his lawyers know, that under the Sullivan standards, there's no defamation here by publishing news of a poll. And so the case is not brought. This is not a defamation lawsuit. This is under this peculiar invocation of the Iowa Consumer Fraud Act. And it's for that reason the case will be dismissed. This is frivolous. This is frivolous, and this is without merit. And yet it's going to be clouding and impacting the conduct of other litigation there in Polk County in the state of Iowa. And that's the other impact of this, pushing out the legitimate actions in the civil arena that can in fact be brought by legitimate litigants, both plaintiffs and defended by defendants. All of that in some ways pushed off, supplanted in ways big and small by the filing of these kinds of frivolous lawsuits. The lawyers know better. And Donald Trump may or may not know better. But it's clear that in the Consumer Fraud Act, there's no case here. Nonetheless, now the newspaper and the other individual defendants, including the newspaper's owner, need to defend against this and will be spending money and time and resources doing just that. And that, in the end, plainly is Donald Trump's point. Let's go overseas to a more positive story coming out of an horrific event. We have talked about this before, coming out of Avignon, France. This will be the third time that we've reported on this major case. Horrific, almost unbelievable in its violent dimensions, having to do with the violent rape, the sexual assault of Giselle Pellicotte over a period of 10 years by her husband, Dominique, and 50 other men in Avignon and the surrounding areas. What do we know about this case in particular, and why is it back in the news just this past week? Well, just this past week, Dominique Pellicotte, he's 72 years old, who admitted during the course of a months-long trial that he drugged his wife for almost a decade and invited strangers into the home that he met on the internet to join him in violating her, engaging in this sexual violence. And I'm hastening to add once again that this is violence. This is not sex. This is a power move. This is powerful violence in the nature of aggravated rape. And indeed, the law enforcement authorities responded to just that. On Thursday of this past week, Pellicotte and others convicted of aggravated rape of this powerful event, of this power crime perpetrated on her, and other charges also coming out of these horrific events disclosed by law enforcement to Giselle Pellicotte when they provided her with pictures of the events themselves, the videos themselves. Giselle Pellicotte becoming, as a result of this prosecution, plainly a victim with a capital V, but also a hero in many, many ways to not only people in France, but around the world. Why? Because she decided not only that she would support this prosecution of her husband, the things that he did to violate her integrity as a human being, her status as a woman in France on the face of this planet. She decided to go ahead not only to pursue this, but also to do it publicly, to let these horrific photographs, these videos that her husband took of these events be published in the public arena of the trial. And as a result, Giselle Pellicotte becoming an icon over the period of the past several months in France, plainly a reluctant icon, but someone who now stands at the forefront of civil rights and human rights in France and across the country. In the wake of the verdict entered just this past week, a crowd of protesters, mostly activists, gathered in front of the courthouse in support of Giselle Pellicotte, once again saying that she has become this voice for reason and for goodness, even in the midst of horrific things being visited upon her. And yes, indeed, also her family. We talked previously about the impact that these events have had upon her family, including her son and especially her daughter, who may also have been the subject of the physical violence visited upon her by her own father. Voices outside the courtroom just this past week saying, we are strong, we are proud, we are radical, and we are angry about what has happened in this case. The family, including Giselle Pellicotte, leaving after months of trial, looking blank-faced, but plainly heroes with a small h. In the wake of what happened to them, victims of the highest order, but people who decided that they were going to turn this horrific thing that has happened to them, Giselle Pellicotte in particular, into a voice for liberty, a voice of fairness and decency, and accomplishing what not a lot of other people can do by virtue of her public stance in all of this. The judges in this case also convicting 50 other defendants. The head judge reading the guilty verdicts one after the other to a packed courtroom, again, where Giselle and her other family members were listening to all of this. Pellicotte was found guilty of raping the wife of one of the other men who was also convicted, and of taking and distributing these photographs and the videos of Ms. Pellicotte. Her daughter Caroline and two daughters-in-law also appear in some of those photographs. An horrific event. The extent of this cannot be overstated. And coming out of it, two big lessons. One is the power of an individual to come forward and, yes, being supported tremendously by the victim support services there in Avignon, but also finding within herself things that would challenge any human being, finding within herself the capacity, the power to come public and to let this go ahead and let it be a voice. The case is a voice. She is a voice for women, and I would offer men as well, who are advocates for decency. And the second point is just that, decency and justice that can, in fact, even in the wake of horrific crimes, be addressed imperfectly, incompletely in the courts of our planet. In this case, a very different system. The international law system has contemplated all sorts of different procedures along the way. We knew the result of this case long ago based upon the testimony, but nonetheless significant in its coming to conclusion, an affirmation now of the power of that court in Avignon. And I would advocate as well around the world, certainly throughout France, throughout the United States of America, for people who find the strength inside themselves as victims to do the right thing, even in the midst of this horrible things having been visited upon them. Giselle Pellicotte, a national hero, I would offer an international hero for advancing our sense of right and wrong, of decency, of what sexual assault is, the power move, the power of violence, the power of crime that it really is, and standing today in the wake of this horrible event, which will forever color her and the rest of her life and all of the lives of her family members. Nonetheless, a hero for what she has done, a justice hero in France and across the planet. When we come back in our final segment, we're going to talk about what the Supreme Court has coming forward based upon the decisions that it made just this past week to hear additional cases in major areas affecting our lives here in the United States. Stay with us for that discussion. our program here this weekend. Justice, law, government, all interacting in our nation, in our state, and beyond. Let's talk about some other things the United States Supreme Court did just this past week, having previously discussed a bit in our first hour the dramatic impact that the Supreme Court has in our lives. Mentioned briefly in our first hour these dramatic cases called Bruin and Heller that changed our understanding of the Second Amendment, that give rise to many of the gun problems that we have in America by establishing this notion that the Second Amendment gives you a personal right to own weapons in America, to have them on your person, to have the capacity constitutionally to carry them, whether it's closed carry or open carry, all of those things coming out of Supreme Court cases called Heller and Bruin. And of course, there's more of that. As I indicated, we've got this Vanderstock case pending for now on whether or not ghost guns can be regulated by the ATF. That may or may not result in a decision coming up in May or June or July of this coming year. But guns and our understanding of them in America, as we talked about them at great length in our first hour, also coming out derivatively from the very decisions made by our Supreme Court, establishing rights that did not exist for most of our nation's history under our Second Amendment. So the significance of what the Supreme Court takes and the cases it does not take cannot be overstated. Last week, we talked about a few cases. The Supreme Court said, nope, we're not going to review those cases. We're going to let the lower court decisions stand. This week, going in just the opposite direction, the Supreme Court adding to its docket that's now above 50, 3 more cases. And you have probably seen in the news something about each one of these. Certainly the first one, very significant. Supreme Court will hear arguments as early as January 10th, next month, early 2025, over, that's right, TikTok's effort to block that federal ban on the platform if it is not sold by January 19th. You recall well, the federal legislature, our Congress, imposed that ban on TikTok. The announcement from the Supreme Court comes days after a lower court rejected TikTok's request for a temporary pause of that ban. Lower court saying, nope, we're not going to interfere with the legislative action. TikTok had argued that a pause in what the legislation would accomplish would afford the Supreme Court some time to weigh the case, and that certainly would have been the situation. But what happened was that in a ruling earlier this month in December, that lower court, it's a 3-judge panel of the Court of Appeals for the D.C. Circuit. Many of our Supreme Court justices come from that panel, rejected the ban that was imposed upon TikTok to overturn the law. TikTok seeking a stay in what our legislature has done. The court found merit in security concerns about potential data collection or content manipulation that was undertaken by the Chinese government. And if the Supreme Court upholds the ban, it will take effect, interestingly, one day before the inauguration of President-elect Donald Trump, who has signaled in many ways that he would consider seeking to reverse that legislative ban on TikTok. Very complicated, but the Supreme Court deciding it's going to have oral argument on January 10th, and maybe, just maybe, issuing some decision shortly thereafter. That they can decide these cases whenever they would like. TikTok now before the United States Supreme Court. We know that in the past term, the United States Supreme Court handled, or more accurately, did not handle 2 cases having to do with abortion, basically saying we're not deciding to decide anything on abortion. Indeed, abortion is back before the Supreme Court in this term. The Supreme Court on Wednesday saying it will consider South Carolina's move, its legislative move, to cut off Medicaid funding to Planned Parenthood. This is the latest abortion-related case, plainly since the justices overturned Roe versus Wade 2022 in that Dobbs case. The court agreed just this past week to take up a state appeal. This is the government, the state of South Carolina, appealing a lower court ruling that focuses on whether Medicaid patients have the ability to sue, whether they can sue over the right to choose their own qualified provider. The case will probably be argued in spring. California, in 2018, had moved to cut off Planned Parenthood. The organization uses Medicaid funding for family planning health services rather than abortions. But Governor Henry McMaster said any public money sent there results in the subsidy of abortion. he said, justifying this cutoff of Medicaid funds to Planned Parenthood. The Fourth Circuit, once again, United States Court of Appeals, blocked that move after a challenge from Planned Parenthood and a patient also involved in this litigation. It found, that is, the appeals court found, that the federal law lets Medicaid patients choose their providers and sue if necessary. This, once again, principally a case involving who can sue, whether they can sue under Medicaid. Fourth Circuit says, yes, you can. Supreme Court now taking this issue up from the Fourth Circuit and plainly, once again, bringing back to its docket issues related to abortion. Plainly, Sam Alito was only too happy in 2022 to say this is a state matter. Didn't say it explicitly, but hoping that abortion would no longer be on their docket. 4 members of the Supreme Court taking this up, saying that, yes, indeed, will weigh the state court move to cut off Medicaid funding from Planned Parenthood, going to be argued sometime in 2025, a decision presumably thereafter sometime in June, maybe even July. Abortion back on the docket of the Supreme Court. And finally, coming out of Wisconsin, a religious case. Supreme Court on Friday of just this past week agreeing to decide whether charities that are run by religious groups have to pay, whether they're obliged to pay unemployment taxes to cover their employees. Now, the reality is that most, but not all states generally exempt religious groups from having to pay into the state's unemployment tax systems. Most states, not all, exempt religious groups. So federal law does exempt religious schools from having to participate in the federal state program. But the Supreme Court has never explicitly ruled on the question of participation by charitable organizations that are run by religious groups. And now, as a basis for its decision to grant this writ of certiorari, the decision to take up the lower court case, the court has agreed to tackle this question squarely on its face. Case brought by Catholic Charities against the state of Wisconsin. The Catholic Charities applied to the state for an exemption from paying unemployment taxes for its employees, but the state of Wisconsin, the Labor Commission, refused the application on the grounds that the charitable group was engaging in activities that are not religious per se, and thus not entitled to be exempt from paying unemployment taxes. Again, an issue under the First Amendment to our Constitution. More of all of that plainly in future editions of Amicus, a Law Review. For this weekend, happy holidays, everyone. We'll be back again next weekend as we talk more about law and justice and government here on Amicus, a Law Review. Have good holidays, safe and secure, all of you, and have a good weekend. Take care.